Here is the rest of chapter 3. So we've already talked about Good Samaritan laws and immunity, but they bring it back up in this chapter for obvious reasons. The Good Samaritan law is based on the common law principle that when you reasonably help another person, you should not be held liable for errors or omissions that are made in giving care. Most states have Good Samaritan laws. To be protected by the provision of the Good Samaritan law, you have several conditions that have to be met. The first is you acted in good faith in rendering care. You rendered care without expectation of compensation, so you working for a service under medical director or a volunteer service, it doesn't count. You acted within the scope of your training. As an EMT, you can't do anything that's outside of the national scope of practice for an EMT. And you did not act in a grossly negligent manner. Gross negligence is defined as conduct that constitutes a willful or reckless disregard for the standard of care or for the duty to act. There's another group of laws that grants immunity from liability to official EMS providers. The laws do not provide for immunity when injury or damage is caused by gross negligence or willful misconduct. Laws vary from state to state. Make sure you know what the laws are in your area and always double check with your medical director. If something goes wrong on a call, let somebody know. Don't try and hide it. Don't try and cover it up. Make sure that you know what you could be liable for. Records and reports. You should always compile complete and accurate records of all incidents involving sick or injured patients. We have patient care reports, but like I said earlier, we're moving from a model, or have moved from a model, where you put everything in writing, document, to check boxes and drop downs. And the information that we have put in these reports is a heck of a lot less than when I started this business. And while it's a lot more easy, it's a lot more efficient, less time consuming, it's not exactly a great thing for us in the business. Those records are your legal safeguard against any sort of complications. They are a legal document. As soon as you sign, it is a legal document. When you have a case called to court, you have a lot of things to consider, and your report is considered a reflection of you. So if it's incomplete, there's a lot of spelling, grammatical errors, they will use that to defame your character, because if you're sloppy in documenting, you're probably sloppy in how you cared. Is that necessarily true? No. And yes, I understand that we are not, out to be English majors in this profession, but there are certain standards that we need to meet of professionalism. And one of the biggest things that you can do for yourself is to know how to communicate effectively through written and verbal communications. That's not something that's going to go away. And it's not text speech where you're LOLing and everything. I do it too, I'm not gonna lie. But that can be seen as a negative for us. And then one other thing that you should know is that if it's not documented, it didn't happen. Irregardless of if it really did, if you don't document something and put it down that you actually gave the medication, that you took the vitals, then it didn't happen. You cannot prove it after the fact. So here's some documentation. This is how I used to write my PCRs, or patient care reports. Everything was filled out, pen and paper. The one on the left, you'll notice that anytime that there's a mistake, there's a line, single line through it, initials and date above it, which you can't even see that closely, but that is the proper way to correct a legal document. If you mess up, one line through it, initial at the very least, you should put a date with it as well. The one on the right, the scribbles, the lines everywhere, not acceptable. Not acceptable at all. Make sure that you keep your reports as clean as possible. Do we mess up? All the time. I mean, I think in this recording section alone, I've made ridiculous amounts of mistakes. Let's just be honest. But because your PCR is a legal document, you have to be very careful as to how the overall look is. Clean, concise, but fully accurate. Special mandatory reporting requirements. There are certain circumstances that, irregardless of the situation, we need to let somebody know what's going on. Most states have a mandatory reporting for certain classes of people. And this could be just any individual on the street or physicians. It oftentimes applies to us as hospital or as healthcare workers. Abuse is first and foremost something that we should report. And this varies from state to state, so make sure you know what your state law is. But child abuse, elderly abuse, or at-risk people, those with developmental delays, certain illnesses definitely make them at risk. Injury during the commission of a felony, drug-related injuries, childbirth in the field, attempted suicides, dog bites, communicable diseases that have the ability to spread, assaults, domestic violence, sexual assault, exposure to infectious diseases, transport of patients in restraints, the scenes of a crime, and the deceased. Those are things that you don't keep to yourself. Somebody needs to know about the majority of them under state laws, but also moral laws as well. Ethical responsibilities. These are the other side of how we should treat people and what we need to do. Legal, there's a law that says that we have to do something. Ethical responsibilities are generally to yourself, your coworkers, the public, and the patient. Ethics itself is a philosophy of right, wrong, moral duties, and of ideal professional behavior. Morality is the code of conduct affecting character, conduct, and conscience. And then bioethics specifically addresses ethical issues that arise in the practice of healthcare. EMTs, for sure, will experience an ethical dilemma within their career. There's no way to get around that. Some things that will happen during your career will cause you to reevaluate your own ethical standards or those of the profession, and you may end up completely changing how you view circumstances. Allow rules, laws, and policies to guide you in your decision making. Be honest, keep accurate records, but listen to that little voice that says something's not right. When we end up in court, you can end up in court as a witness or as a defendant. The case could be either civil or criminal. Whenever you're subpoenaed to testify or when you ever get called in to testify in a court proceeding, you should immediately notify the director of your service and seek legal counsel. Typically, something will be provided for you. As a witness, you remain neutral. It's not your job to say what you think happened. It's facts. Everything is facts. Review the run report before your court appearance. Most days I can't remember what I had for dinner the night before, let alone a call 5 years ago, 3 years ago, a couple of weeks ago. There are certain calls that stick out in my mind, and I have details about that, but for the most part, there's no way I'm going to remember a call. That's partly why thorough documentation comes into play, because you might not remember what you're being subpoenaed for. You sit down with that run report and start reading it, and you're like, oh yeah, okay, I remember this. And it might jog your memory. Otherwise, you may just have to go off that run report. And they say, well, did you do this? Well, I'm sure I did. No, is it in your report? Did you perform this, whatever it is? If you can't point to that report and say, yes, I documented here that at this time I did this, then they can say you didn't. As a defendant, you will have to have an attorney, period. That attorney is generally going to be supplied by your service in a civil suit. And just defenses that may be used is statute of limitations. That's the time where the case must be commenced, or you're no longer to be liable for it. Governmental immunity is generally applied to municipalities or other governmental entities. If your service is covered by immunity, it may mean that you cannot be sued at all, or that it would limit the amount of monetary judgment that can be recovered by the plaintiff. And then contributory negligence is a legal defense that may be raised when the defendant feels that the conduct of the plaintiff somehow contributed to injuries or damages sustained by the plaintiff. Discovery. This is an opportunity for both sides to obtain more information to kind of understand the case. This is performed through interrogation, written requests or questions, or depositions, which is oral requests or questions. The trials themselves, most cases are settled following the discovery phase well before things go to trial. However, those that aren't settled do go to trial, and several types of damages may be awarded. Some can be compensatory damages that are intended to restore the plaintiff to the same condition he or she was prior to the incident, or punitive. Punitive damages are intended to deter the defendant from repeating the behavior and are reserved for cases when the defendant has acted intentionally or with reckless disregard for the safety of the public. These damages are not commonly awarded in negligence cases, though. All right, so the summary is on here. You can feel free to go through that on your own on the JB Learns site. Other than that, this is the end of Chapter 3, and Chapter 4 will be posted shortly.